Good morning. My name is Alberto. I am a senior lecturer at the Chair of International Law of KAZGUU University. In this video, I will try to introduce you to the basic principles and the basic features of international investment law. As you probably know, international investment law is the branch of public international law which regulates the relationship between states and a special sort of investor, private foreign investors. Already in 2005, UNCTAD estimated that the global foreign direct investment flow was of beyond $1 trillion. So international investment plays a very important role in the global economy and has a deep impact in the states that host it. As such, the relationship of investment is based on three very different actors. Foreign investors, which could be private, legal, as well as physical persons. Host states, which are the states that receive the investment. And finally, home states, that is the state of nationality of the foreign investor. This very complex relationship is regulated by a network of approximately 3,000 international investment treaties. The majority of these treaties are bilateral. For instance, the bilateral investment treaty between France and Kazakhstan, or between the USA and Kazakhstan, while an important number of such treaties is multilateral. An instance of this is the Energy Charter Treaty, of which Kazakhstan is also a party. Kazakhstan itself has signed or ratified approximately 50 different investment treaties. Now, these investment treaties have two kinds of provisions. The first is substantive provisions, that is, provisions setting out the rights of the investor once he is inside the host state. These include the prohibition to expropriate, that is, to take the investment in an arbitrary manner, or the obligation to accord fair and equitable treatment to the investment. A second type of provisions in any investment treaty are the so-called dispute settlement provisions. These are very important because they give to any foreign investor the right to bring a claim directly against the host state before an ad hoc international arbitral tribunal. In this way, they don't have to go before local courts and they don't have to ask the diplomatic protection of their home state. In this way, corporations, which are usually not persons of international law, become the beneficiary of extensive rights and also the possibility to enforce these rights directly against states, which you can see is a very interesting and atypical situation in international law. Now, particularly in the last years, international investment law has come under a great deal of criticism. Critics see investment treaties as being a great intrusion in national sovereignty because they give to investors the possibility of simply ignoring national legal systems and ask damages against states under international law. Let me provide you a few examples to illustrate the controversies and dangers of international investment law. The first is the ongoing case, which is Vattenfall versus Germany. In 2011, Germany decided to end its nuclear energy program in order to start the transition towards green energy. Vattenfall, a Swedish energy company, decided to bring a claim against Germany under the Energy Charter Treaty, of which also Kazakhstan is a state party, arguing that this policy decision amounted to an illegal expropriation, that is, the taking of the investment. Vattenfall asks for a compensation of $4 billion from Germany. So you can see from these two examples that international investment law and investment treaties may constitute a danger for states as well as a great resource. It is so very important for both private and public lawyers to know very well international investment law and be able to understand what these bilateral and multilateral investment treaties contain. Hopefully, over the next few weeks, I will have the possibility and honor to teach you the basic substantive provisions of international investment law, as well as the dispute settlement procedures which feature in these very interesting treaties. That will be all. Thank you very much.